Welcome back to Cool as a Cucumber, How to Testify Successfully at Your Deposition or in Court in a Domestic Relations Case, Part 11, in which we discuss Deposition Golden Rule number 10. That is, I don't know and I don't recall are acceptable answers when they are true, meaning that you really don't know. All your life, you've been coming up with the right answers, be it answering questions on school and licensing exams or accurately answering questions at work. Knowing the right answers matters there. Knowing the right answers, so to speak, to critical questions can greatly affect your success in life. The world rewards knowing the right answers and often punishes not knowing the right answers. Depositions are different. In a deposition, sometimes you simply don't have all the answers. It's not your fault, so don't act like it is. You do not need to have all the right answers in a deposition. You are not expected to have all the answers. You can't have all the answers. When you act like you do have all the answers, but you really don't, that's lying. It's human nature to want to avoid looking foolish and ignorant, but the opposing attorney in your case is playing upon your vanity and pride to make you guess, to speculate, to claim you know the answer when you really don't. And if the opposing attorney succeeds at this, you look like a fool and/or a liar. Do not succumb. It is the attorney's intent to exhaust your knowledge. Fair enough. The attorney will ask, is there anything else, or is there any other reason, or do you have any other things to say? Do not try to come up with a right answer. A deposition is not a test you have to ace. You simply want to tell the truth in response to the questions to the extent that you know the truth. When the opposing attorney asks, for example, is there anything else, or is there any other reason, or do you have any other statements you wish to make? Do not answer no to those questions. No is an unequivocal denial. Rather, state, that is all I can recall at this time, or I don't presently know, or a similar response. Leave the door open for any later recollection that may occur prior to or at the trial or hearing. If you claim to remember nothing else, if you state that you've forgotten or omitted nothing in your testimony in the deposition, but are then confronted with a document or witness that shows otherwise, you may not look merely forgetful. You'll likely look like, or be painted to look like by the opposing attorney, to be a liar. I don't know will often be a more truthful response than attempting to guess or speculate at a correct answer to the question. For example, have you ever spoken with the school principal? That's an extremely broad question. It refers to your entire life, not just in the context of the pending lawsuit. Did you catch that? Without spending the time to review your entire life, simply answering no may be inaccurate. A response such as, I do not recall meeting the principal, or I do not recall meeting the principal recently, or I am not sure, is entirely more accurate, more honest. While your answers should be brief and to the point, be wary of unequivocal yes or no responses to some questions. Here's an example of how to handle this the wrong way. Question, so are these 7 accounts you identified all of your financial accounts? Answer, yes, that's pretty much it, or answer, yep. Don't do that. Here's an example of what to do. Question, so are these 7 accounts all of your financial accounts? Answer, as best I can recall at this time, yes. Question, stated in a sarcastic way calculated to make you feel stupid. You mean you don't know how many accounts you have? Answer, these 7 accounts you ask about are what I can remember at this time, Mr. Smith, but I can't say with absolute certainty that my accounts are limited to these 7. Here's the next question. Well, take a moment and think about it. I don't want you leaving out key information. That's exactly actually what he wants you to do. Answer, Mr. Smith, these 7 are what I can remember now. If I discover anything else, I will notify you through my lawyer as soon as I do. Now, if you think that claiming not to know the answer to a question is a good way to avoid having to answer the question truthfully, think again. Most people's BS meters are pretty well calibrated. If you consider yourself to be a skilled liar, you're likely only fooling yourself, not others. Here's an example of a don't. Question, did you hide your bonus from your spouse? Answer, I don't recall. Question, you don't remember whether you hid your bonus from your spouse? Answer, that is correct. I don't recall. Question, did you report income of $50,000 on your 2014 tax returns? Answer, I don't recall. Question, but your year-to-date pay stub statement states your income for 2014 was $76,000, right? Answer, I don't recall. Well, take a look, sir. Here is your tax return. Here is your end of year pay stub. What do they state? Answer, that I reported $50,000 bonus income on my tax return and that my pay stub shows total annual income of $76,000. Question, is your tax return accurate? Answer, I don't recall. Question, is your pay stub accurate? Answer, I don't recall. Now here's an example of do. Question, did you hide your bonus from your spouse? Answer, yes. Question, why? Answer, I was so bitter and hurt over her affair that I felt she didn't deserve any share in it. Now this doesn't make what the husband did right, but it's a heck of a lot more understandable and believable than I don't recall. Husband may take a hit for admitting to concealing the bonus, but his credibility won't be shredded as it was in the ridiculous I don't recall example.